whereas the third accused had the case of conspiracy to murder to answer. The particulars of the first count read as follows. Kumwembe, Pika Manondo, and Raphael Kasambara, on or about the 13th of September 2013, at Area 43 in the city of Lilongwe, attempted to unlawfully cause the death of Paul Mpuyo with malice aforethought. So correction, Kasambara was not answering to the charge of attempted murder, since he was acquitted at the stage of no case to answer or case to answer. In relation to the second charge of conspiracy to murder, the particulars read as follows. Kumwembe, Pika Manondo, and Raphael Kasambara, in or around the month of August and September 2013, conspired together to cause the death of Paul Mpuyo with malice aforethought. To prove its case, the state brought 15 witnesses. The first accused called 11 witnesses, whereas the second accused called 2 witnesses. The third accused chose to remain silent, even though practically all the witnesses called by the first accused were in fact his witnesses. This was according to the assertion of the third accused, because there is no propriety in a witness, and as the charge of conspiracy related to all the accused persons. Having previously found that the state had made out a prima facie case against the accused persons, it is up to the court now to decide whether the explanations given by the accused persons are not only possible but at least probable, and whether sufficient doubt has been raised with respect to the prima facie case raised by the state, to such an extent that it can be said that even though the state had initially made out a prima facie case, it has not eventually made out a case beyond reasonable doubt. This is because it is the state which has the duty to prove the case, not the accused persons. So that was the background. Now the applicable law. Attempted murder, the first count, the prosecution must prove that there is an attempt to cause the death of a person, 1. And 2, that the attempt was caused by an unlawful act or omission of the accused person or persons. And 3, the accused person or persons made the attempt to cause death with malice aforethought. So that goes to the 2 elements of a criminal case, that there must be mens rea, a guilty mind, and actus reus, the unlawful act. The court agrees with the assertion made by the DPP that there is a scarcity in local jurisprudence on the law governing attempted murder. We normally have murder jurisprudence in abundance. So she cites the UK case of Colon versus Her Majesty's Advocate, but concludes that it's essentially similar in that an attempt is the murder which has not been effected. Conspiracy is an agreement between 2 or more persons to commit an unlawful act. And this was said in the case of the Republic versus Honorable Dr. Kasim Chilumpa and Yusuf Matumula, as per Justice Nyirenda as he then was. A conspiracy can be expressed or implied. There must be 2 or more persons, because a single person cannot conspire. News versus the Republic. And whether a conspiracy exists, just like whether a murder exists, may be an issue of inference from the facts, in that there is not always a need to have direct evidence. You can have circumstantial evidence. But where the offense, particularly the agreement, is thought to be inferred solely from the conduct of the alleged conspirators, such an inference, as my attention has been drawn to that legal position by the accused persons, such an inference must be consistent with all the facts which have been proven, and must exclude all other reasonable inferences. That's the case of the Crown versus Blom. But it's important to note that there is no need for the state to produce a witness to a conspiracy, because conspiracies are not done in the open. They are obviously done in secret. The burden of proof and the standard, as indicated earlier on, it is on the state to prove the case and not the accused persons. And in a criminal case, the standard is one beyond doubt which is reasonable, as opposed to in a civil case where the standard is on a balance of So in simple language, in a criminal case, you need a proof which is over 90-something% to convict somebody, whereas in a civil case, over 50% might be sufficient, a lower standard of proof. But when we say that the state must prove the case beyond doubt which is reasonable, we don't mean that it should be beyond a shadow of doubt. So there could be some doubt, but if it is just a shadow of doubt, a conviction can still be sustained. Identification. The law on identification in Malawi was adopted from the English case of R versus Turnbull. The adoption was made by the local case of Chapingasa versus the Republic. So tests have been laid down to decide whether identification should be accepted or not. And these tests include the length of time the witness had the accused under observation, what distance, lighting conditions, whether the accused had been seen before by the victim, and if there is a discrepancy, material one, between the observation and subsequent identification. So there are those factors the court has to consider in assessing whether evidence of identification is reliable or not. But the purpose of laying down these rules is not to make identification difficult for victims. It is simply to have guidance, because we have also to balance the interest of the accused persons, in that they need protection, and that the identification should be one that is reliable. Evidence and analysis. What time was Paul Mpuyo shot, and what were the circumstances? There are contradictions from prosecution witnesses as to the time that Paul Mpuyo was shot, a range of about 2 hours. And so the accused persons have submitted that that raises serious doubt about the case of the prosecution, in that the time of the shooting is not quite clear. and also how many people were there on the scene. Mr. Mpuyo's guard said he just saw one man standing next to the window of his boss, who fired 3 shots, whereas Mr. Mpuyo said that he saw 3 to 5 people. So those contradictions or differences, whether they affect the case of the prosecution. So it is the contention of the accused persons that the court should accept the evidence of the guard of that of Mr. Mpuyo, because according to them, the guard was sober, had no interest in the case when Mr. Mpuyo was coming from a drinking place. So starting with the time of the shooting, what time was it? After considering the issue, it is the court's finding, because the guard admitted that he was not sure of the time, as he was not wearing a wristwatch, his time perception is unreliable. I would accept the evidence of Dr. Ntaba and Dr. Valera, the medical doctors, who stated in evidence that they received a call about the shooting after 11 p.m. That's when they went to assist. As rightly submitted by the DPP, medical doctors, by the nature of their duties, will be more exact as to time than ordinary people. Regarding whether there was one person at the scene of the crime, as PW1 indicated, the guard, or 3 to 5 as PW2, Mr. Mpuyo, indicated, it must be noted that the guard was inside the gate and was only peeping through a hole, whereas Mr. Mpuyo was outside the gate, and between the two of them, Mr. Mpuyo had a full vision of the crime scene. I therefore accept the version of Mr. Mpuyo regarding the number of assailants. When finding that the identification on the scene of the first accused by Mr. Mpuyo was not reliable, in the ruling of case to answer, I accepted the version of the guard that the main assailant was wearing a mask over the version of Mr. Mpuyo that he was wearing a hoodie. The DPP has employed me to reconsider my position on the basis that the guard saw the back of the head of the assailant, whereas Mr. Mpuyo saw the front, so that Mr. Mpuyo's version is more acceptable. I declined to adopt the course proposed by the DPP. Even if I did so, that would not change the fact that no ID parade was organized by the police, at which Mr. Mpuyo could pick out the first accused, who was only identified in the dock. And according to our law, dock identification is not acceptable. The DPP brought to me the Supreme Court of Appeal case of Chimwala versus the Republic, which said that sometimes you can accept dog identification. But on the facts of this case, I still maintain my earlier stance that the dog identification is not reliable, particularly also that it was made belatedly, not the first thing that was done when Mr. Mpuyo began to testify. But regarding the description of the assailant as a tall, slim young man, there has been disagreement between the state and the accused persons whether the first accused fits the description of a tall, slim young man. After observing the first accused closely, I find that he is a tall man. Looking at him, his age also in the charge sheet, I find that he is a young man. He's not a boy or an old person. Whether he is slim is a matter which is relative. And I find that he fits the description of a tall, slim, and a young man. But after making that finding, I must say that that does not dispose of the identification, because there obviously are a lot more people who fit that description of tall, young, slim men. And therefore, there's need to have more other evidence to point to the first accused as having been on the scene of the crime on the night in question. Documented and placed alibi of the first accused. The accused persons brought to my attention the case of Okunyenji and Ano versus the state from Nigeria about alibi, that if one brings an alibi, then that is negating their presence on the scene, is negating both mens rea and actus reus. But the onus is on the accused to adduce evidence which sufficiently contains the particulars of the alibi. Nosisi versus the state. So looking at the documented alibi, the first accused produced a passport which had stamps from Malawian side that he exited Mwanza on 30 August 2013 and entered the Zao on 14 September 2013. And the accused persons have cited the Philippine case of People versus Web, that when you have passports which have been stamped by government officials, then that should raise the matter that they are correct, they are accurate. And in the Web case, the court deplored the habit of the High Court there to look at a passport of Mr. Webb very suspiciously, despite it having been stamped and certified by responsible officers. So relying on this case, it is submitted by the first accused that the stamps in his passport have established that he was in Mozambique at the time of the crime. The DPP has, however, argued that the Webb case must be distinguished from the facts of this case. In the first place, it was decided based on laws which are not applicable in Malawi, that in Malawi we apply the Criminal Procedure and Evidence Code, Documentary Evidence Rules, and the Authentication Act. And that under these acts, a passport is not a public document, so that unless there is certification and authentication, as was done in the Webb case. In the instant case, no official from immigration certified that the stamps were correct. So that according to the state, that case is distinguishable from the case at hand. I agree with the position taken by the DPP and find that the Webb case does not apply to the case at hand. It has also been submitted by the accused persons that in the present case, the police did not investigate the defense of alibi when the first accused person told them that he was not in Malawi but in Mozambique, and that that somehow makes the case of the state not quite convincing, that the investigators did not check with people on duty both in Malawi and Mozambique whether the stamps were authentic or not. It must, however, be said that the state did call one witness from immigration to dispute the authenticity of the stamps, but his evidence was thrown out as being hearsay evidence. So that's about the documented alibi issue, whether the passport stamps in the passport of the first accused have shown that he wasn't in Malawi, but he was in Mozambique. And I find that that has not been shown simply by the stamps in the passport. I now move on to the place alibi. After arrest, immediately, as I've said already, the first accused stated that he was in Tete, Mozambique at the time and day of the shooting. And he produced the passport, as I've indicated, showing exit stamps, Mwanza border, 30 August 2013, and entry, Denza border, 14 September 2013. So there were corresponding stamps from the Malawi and Mozambican side in the passports. And the accused persons have cited to me Blackstone's Criminal Practice 2004 for the proposition that where the case includes the case of the prosecution is one which is based on circumstantial evidence, putting the accused at a particular place as the case at hand. Then if the accused says that he was elsewhere, there's no obligation on the defense to give particulars of alibi. And the case cited is Regina versus Lewis. It must be noted that in Malawi, the law of alibi is dealt with under a specific provision, Section 193A of the Criminal Procedure and Evidence Code, which provides, one, that as early as is practicable reasonably, and in any event prior to the commencement of the trial, the defense shall notify the prosecution of its intent to enter the defense of alibi. Two, the notification under 1 shall specify the place, the place or places at which the accused claims to have been present at the time of the alleged crime, and the names and addresses of witnesses and any other evidence upon which the accused intends to rely to establish the alibi. According to the submission of the accused, their construction of 1982 is that there is no need for an accused to give names and addresses of alibi unless he wants to call those people to testify. And that's why the first accused did not give names and addresses. When one reads at 193A2, it talks about which the accused intends to rely. Doesn't say intends to call or something like that. So construction of that provision, to me, does not mean that when one wants to, when there is circumstantial evidence and one doesn't intend to call any witnesses, then you don't have to give their particulars. I would think that there's a requirement to give particulars of alibi for the state to investigate the matter. And this section does not state that there's no need to provide an alibi where the evidence against an accused is circumstantial. But if an accused person has failed to provide details of alibi at the earliest point before the trial, that is not fatal, because they are still allowed under 193A3 to call evidence of alibi. But in this case, there won't be a duty on the prosecution to investigate the details of an alibi which is given that late. And the state can simply rely on evidence from their part to discredit the alibi. The question then becomes whether the place alibi was given regularly. As I have said, the first accused did not provide a place in Tete where he went. He could not even tell the lodge where he slept, so that the state could investigate the alibi. No names were given or persons that he had met in Tete. The first accused testified at one time in cross-examination that he wrote the names of the persons he had met in Tete in a diary, which he had misplaced, and which he would provide if he found it. That diary was never presented. Police investigator Chilinda, PW11, testified that he met the first accused person at Bwandiro on 30 August 2013, and that the first accused later on went to meet him at his office. So that the purport is to say that it's not true that the first accused was in Mozambique after 30 August, if he could be in Malawi on 30 August and 1 September. A bus ticket dated 30 August, although without a year, was found in the possession of the first accused when he was arrested at the Vumbwe government rest house. While appreciating that the state has the burden to disprove an alibi, the second accused did not, in cross-examination, dispute that the bus ticket was found in his possession. The only issue was the year, that there was no year. 2013 wasn't there. I wonder whether it would be reasonable to conclude that somebody in 2013 would have a bus ticket in their possession of a year area or 2 years area. And when I consider the facts in this case, I find that the first accused was in Lilongwe on 30 August, and such that there was no need for the state to investigate at Mwanza border whether he had actually exited Malawi as indicated by the passport. The accused submitted that the prosecution should have called the other officer who was with Mr. Chilinda at Bwandiro on 30 August when he said that he had met the first accused. And that failure to call additional witnesses to corroborate Mr. Chilinda was fatal to the case of the accused person, was fatal to the case of the prosecution. On her part, the DPP has submitted that there is no need to call many witnesses to establish a fact, that one witness is sufficient. It's not the number of witnesses, but perhaps the quality and other corroborating facts. And she has cited the case of Ziambo versus the Republic, and also Republic versus Maxwell Namata. In the end, I find that the place alibi was not given regularly, and even if it was given irregularly, it has been discredited by the evidence from the prosecution. The next question to consider is the second accused. Is his identification by PW2 credible? In the ruling of case to answer, I found that the second accused was seen by Mr. Mpio at the scene of the crime, and he was able to identify him at a distance of 3 to 5 meters when we went to the scene on one night. That time, Mr. Mpio was inside the gate, and the second accused, Mr. Manondo, was outside the gate. After that ruling of case to answer, there have been protestations from the accused side that this does not make sense, that Mr. Mpio could have seen Mr. Manondo. Because if he had seen Mr. Manondo, as he claimed, then Mr. Mpio, it wasn't sensible for Mr. Manondo to go to the scene of the crime without wearing a mask when the shooter was wearing a mask. That it doesn't make sense at all. And that if Mr. Mpio had seen him, he would have mentioned this in his first witness statement as opposed to a subsequent one. That is not making sense that after being seen by Mr. Mpio on the scene of the crime, then Mr. Manondo would have gone to the hospital at Kamuzu Central Hospital. Doesn't add up. After hearing those protestations, I reconsider my finding. It is now my finding that Mr. Mpio did not see Mr. Manondo at the scene of the crime. Therefore, it becomes necessary to consider whether there is other evidence which places Mr. Manondo at the scene of the crime. At the end of the case, defense case, the state asked for leave for them to call rebuttal evidence because Mr. Kumwembe had mentioned late in the trial, in cross-examination, that he had left his phone with Luciano Chiumbuzo when he was in Mozambique, that Chiumbuzo was using the phone to transact business. So I allowed that evidence to be called, whereas Mr. Kumwembe had mentioned that Luciano Chiumbuzo was a blood relation of his, the daughter of a younger sister to his mother. It later transpired that there is no blood relationship between Mr. Kumwembe and the Chiumbuzo family. And Luciano in court denied that he was ever in Malawi on 12-13 September. And he was not using Mr. Kumwembe's passport, Mr. Kumwembe's cell phone. His brother, Luciano's brother, also said that it wasn't true that Luciano was in Malawi, because if he was, the brother could have known, and the brother had stayed at Mr. Kumwembe's house in St. Mary's Zomba at the same time that Luciano was supposed to have been staying there, so that he should have met Luciano if he was in Malawi. I also allowed Mr. Kumwembe to call Saribato evidence. Now, after all this was done, I have been implored by the accused persons to expunge this evidence from the record, that the evidence, rebuttal evidence, was wrongly admitted, its prejudicial value to the accused persons outweighs its usefulness. And the argument being made is that in rebuttal, for you to call rebuttal evidence, you need to show that something new has cropped up, which you did not know, and which, as an investigator, you could not have found out by a sensible investigation. And the dictum of Chief Justice Spencer Wilkinson in Dines versus Regina is relied upon. So the accused persons conclude that just like in Dines' case, the issue of somebody using the cell phone wasn't new, so that the evidence should be expunged. Does not qualify to come in as rebuttal evidence. Having considered the matter, I find that the name of Luciano Chumbuzo was brought in belatedly and reluctantly by the first accused in cross-examination. And I find that it related to a new aspect in his defense of alibi. I therefore refuse to expunge the evidence I admitted from the record. And if I am wrong to refuse to expunge the rebuttal and rebuttal evidence, it will also be necessary later on in this judgment to consider whether there is other evidence which can show up the case of the prosecution. I have produced collogue extracts in the judgment. First accused number 0999226214, communicating with Mr. Kumwembe's number on 12 September 2013, showing Mr. Kumwembe's number moving from Vumbwe in Blanta through Limbi Market, through Zomba, through Tunga, and so on, eventually landing up in Lilongwe, that number. It was in Lilongwe, the number 1213 went back to Blanta after Mr. Mpuyo was shot. So I've also produced communications, actually between all the three accused persons. And reference will be made to the communications later on in this judgment. Has the prosecution proved a case of attempted murder against the first and second accused beyond doubt which is reasonable? Since I have found that Mr. Mpuyo actually did not see anybody, any of his assailants, then the case for the state becomes circumstantial, based on collogue evidence, principally, and other evidence as well. Now, there's been an attack by the accused persons on collogue evidence that is not reliable. It's showing, for example, the second accused moving from one place to another, short space of time. But the accused persons, at the same time, in another breath, as the DPP pointed out, use collogue evidence to substantiate their own movements to State House and so on. So in one breath, the collogue evidence is not reliable when the state wants to support its case, but when the collogue evidence is supporting the case of the accused persons, then it is reliable. Can you convict somebody based on collogue evidence? The accused have submitted that you cannot, because collogue evidence does not place somebody in an exact area. It's just a general locality. And you don't have recording of the conversations. And unlike GPS where you could know where somebody is exactly. Now I wonder how and why. How will you get GPS unless you are in advance following somebody and you tag them up so that you have GPS pointing their exact location. The accused persons have relied on the case of the Republic versus Mvula Supreme Court decision, which throws doubt on placing reliance on call-log evidence to convict somebody. Justice Toya, Justice of Appeal, in delivering a judgment of the Supreme Court of Appeal in Malawi, said, I quote, "It is our view, therefore, that notwithstanding that the respondents had been in contact with each other at different points in time, on the totality of the evidence, it cannot be said that they acted in concert of an unlawful purpose." And he cites the case of Crown versus Bailey. So on the basis of the facts before the court there, the judge said we would not have found that a conspiracy had been established. And they agreed with the High Court. On our part, the DPP has argued that you can convict somebody on call-log evidence. Cited the case of Adiojo Nyamufukuza versus Regina, where call-log evidence, just cell-site evidence, was enough to convict somebody of murder and attempted murder. The DPP has also cited the case of Director of Public Prosecutions versus Valac, British Virgin Islands, where there was a communication between accused persons which was analyzed by the judge, and it pointed to something happening, and convictions were sustained on the basis of that call-log. It is my finding that in the Republic versus Mvula, the Supreme Court of Appeal in Malawi took the position they did, and because of, on the basis of the evidence before them. So in the quotation that I gave, I would be emphasizing the words on the basis of the evidence before us. So each case has its own peculiar features. We can't say that you cannot convict somebody on the basis of call-log evidence. You can, depending on the evidence before the judge in question. Now, when you examine the call-log communication between the first and second accused, so actually I found that the first accused was in Malawi on the date in question. His phone was not with Luciano Chumbuzo, as he claims, and he was using it himself in Malawi. And when you analyze that evidence, you find the movement and communication between the people First accused was in Lilongwe on the night in question. His number was in Lilongwe. There was communication with the second accused in the morning, although there wasn't none later on in the day. And then after the shooting, there was communication early in the morning, and the number travels to Deza. First accused number and second accused number. And the state submitting that the purpose of stopping at Deza must have been to stamp the passport. And the number goes back to Blantyre. First accused number also comes back to Lilongwe on the 14th and goes back to Blantyre on the 15th, and later on he is arrested with a bag of money in an MCP bag, 2,150 kwacha. And the state submitting that this money must have been given by Mr. Manondo to Mr. Kumwembe as a payment for the shooting which had been done earlier on, by analysis of the movements of the phones. Now let me talk about the alibi for the second accused. I've talked about the alibi for the first accused and dismissed it as not being truthful in nature. So the second accused alibi was Gostin Chinseu. This name was introduced very late in the proceedings by the second accused, who was saying that after case to answer, that I'm not sure I want to go and find out who must have seen me after 11 p.m. Then he comes and says, met Gostin Chinseu, who reminds me that he met me at Shentemba. And it's only Gostin Chinseu who met Pika Manondo. There's no other people who met these persons at Shentemba. And the DBP is wondering how somebody could go on a drinking spree all alone without anybody else meeting them. Gostin Chinseu in court said that he had not discussed coming to court to testify for Pika Manondo. And yet Pika Manondo had earlier on said that I talked to Gostin Chinseu, who reminded me that he met me at Shentemba. So the state concludes that this alibi must have been manufactured, a clever afterthought. And I agree with the state's position. Now there was money which was paid to Mr. Kumwembe from Mr. Manondo. Some money earlier than 30 August, some money on 30 August 2030, and some money subsequently, some of the money which was found with the first accused at the Vumbe government rest house, according to the state submission. The money was found soon after Mr. Kumwembe returned from Lilongwe, after several of communication showed that he had been in contact with Mr. Pika Manondo. And there have been explanations about the money. One of the submissions by the accused person is if Mr. Kumwembe was in Lilongwe on 30 August 2013, then why deposit money in his account? Why not just give him cash? It's not unusual for somebody to deposit money in their account if you don't want to travel with large sums of money. The other explanation for the money was that it was for political activities. of destabilizing MCP convention, whereby the idea was to have Mr. Muno's delegates not attend the convention. And the DBB wondered how come that this money was being given after the convention had taken place, if the idea was to disrupt the convention, the delegates of Mr. Muno. For the money which was found in Mr. Kumwembe's possession at the Vumbwe government rest house, there were two explanations given by Mr. Kumwembe. First, in his caution statement, he says, quote, Mzanga Robert Kadzua anatoa chikwama momwe munali ndalama kenako tinapitirira kwa Vumbwe kuti tikagawane ndalamazo zomwe zinali mu chikwama cha Black zinalembedwa mawu a Malawi Congress Party. Chikwama cha Robert Kadzua anachitenga mu galimoto ya saloon ya white ya mtundu ya Corolla. And when Mr. Chilinda had taken Kadzua and Kumwembe to show him where they had picked this bag of money at ShopRite, each one pointed to a different location. And later on in court, explaining the same money, Mr. Kumwembe says that it was given to him by Pika Manondo in the company of Rutepo and so on. So two contradictory explanations for the money. They cannot be both true. One of them or both are not true. Now, perhaps I should go back a bit and talk about the issue of alibi, because I found earlier on that the two alibis were false: alibi for the first accused and alibi for the second accused. Now, if somebody gives a false alibi, does it mean that they are guilty automatically? And the law is that the mere fact that an accused brought up a false alibi does not entail that he is guilty, because they could have been misguided. And Justice Cram in the Republic versus Kalua said that an innocent person in the predicament of a trial may foolishly lie. So, it must be. There are some people who maybe have a very good case, but they want to add salt and pepper to the case. A very good case already, but wanting to add salt and pepper when it's not necessary. It happens on both sides, like in this case. From the state side and the accused side, you have salt and pepper, sometimes where not necessary. And it reminds me of, I read somewhere, somebody was saying the job of a judge is a very difficult one. You have two sides who are all telling lies, and the judge must find out who is telling less lies. But that's not our job. That's not how we operate. I have to correct that misconception. That our job is to find out who between two sides is telling less lies. We have principles which we use. For the witnesses of the prosecution, if somebody tells a lie somewhere, it's not meaning that you don't believe. You have to look at all the evidence, and if there's other evidence corroborating them, then you can find the case has been established. Even though some lies were told, or maybe lie is too strong, but some statements which were incorrect. So this has been the position in JNN versus the Republic and the Punch versus the Republic about the side of the state. Any things which look like lies, you don't just dismiss the case because somebody has been incorrect somewhere. I'll come back to that issue of the prosecution, incorrect statements, or lies if you may want to call them, how to assess that evidence. Do you throw it out outright or not? But I'm talking about the false alibi now on the part of the defense, that it's not always going to indicate that somebody is guilty because they gave a false alibi. Karua, Republic, Karua. But on her part, the DPP has said that sometimes there are lies which are told where they are probative of guilt. No innocent person would tell such a lie. Telling such a lie means the person is aware that the truth will convict them. So the DPP argues about the lie about the phone number of first accused being with Chumbuzo, that is probative of guilt, and that nobody who is innocent can tell that lie. So that although false alibi is not automatically bad for an accused person, but that's not here. Edwards versus the Crown. That is the case. I find that the lies on alibi told by the first and second accused are probative of guilt, that no innocent person would tell. And telling those lies means that the accused must be aware that the truth will convict them. In the totality, I find that the state has proved their case against the first and second accused on the charge of attempted murder. But maybe I need to give a background as well as to why I am arriving at that conclusion. More discussion on the cell phone evidence, on the charge of attempted murder, first and second accused. There was the second accused who was captured, Airtel 43 G1, was captured by Airtel Tower G1 43, and the claim was that he was in Pacific Mall and could have been captured by 43 G1 in Pacific Mall. So we had evidence from Mr. Goera who said that ESCOM the towers, Airtel towers, the way they are tilted, they try to avoid overlap, and that somebody who was at Pacific Mall, as the second accused says he was, could not have been captured by 43 G1. Although sometimes it's possible for there to be a spillover, but that can only happen if it is a peak hour. So the time that the second accused was captured by Tower 43 G1 was off-peak hour, and he could not have been captured by 43 G1 unless he was in the area that was being serviced by for the 3G1. That is the area of Full Garden and Mazim, German Embassy, covering the residence of Mr. Paul Hill. So in my analysis of the cell towers, I have found that the prosecution has made up the case of conspiracy to murder against, the case of attempted murder against the first and second accused persons. Last question is, has the state made out a case of conspiracy against the 3 accused persons? So I indicated earlier on the communication between Mr. Kumwembe and Mr. Manondo, and we find that eventually the 2 phones are going to Blanta after the shooting of Mr. Mpio, and sometimes the 2 phones converge closer to cell towers, which are near, suggesting a possible meeting between the parties. Now, on the conspiracy charge, with respect to the 3 accused persons, the DPP has made the following submissions. It is that 3 minutes after receiving Mr. Mpio had testified in evidence that on the night of 13th September 2013, he had gone to drinking places and he had received a call from a number ending with a lot of sevens, which he said belonged to a minister, the 3rd accused, whose number actually ends with 2 sevens, and that he had lied that he went to Kasambara. Mr. Mpio had said that he was receiving threats from the 3rd accused about payments to persons not entitled to the payments. But the 3rd accused had argued that actually Mr. Mpio's job was not one of authorizing payments. He was a mere budget director who had no such powers. Those powers rested with the Secretary of the Treasury, ST, not Mr. Mpio. And in the case to answer stage, the court found that actually Mr. Mpio had some powers to authorize payments from what had happened. And in fact, Mr. Lutepo, who came to testify, said that he was introduced to Mr. Mpio by Mr. Manondo, so that his payments could be facilitated. In the words of Mr. Lutepo, I was told that if you play ball, then your payments are going to be met. In a way, confirming that actually Mr. Mpio did have powers to do something about payments. Even the witnesses from Reserve Bank of Malawi, Mrs. Kumbatira in particular, testified that there were some payments which were made outside the country, which Mr. Mpio alone was aware of and others weren't aware of, indicating that Mr. Mpio indeed had powers to make payments. So Mr. Mpuyo had testified that he was receiving pressure from the third accused to make payments. And as I've said, the third accused disputes that actually the payments that were being referred to belonged to Mr. Mpuyo and his friends, that the third accused in fact had made negotiations to lower down some claims, such as for Deco Terrace Stone, which reduced by about 2 billion kwacha. Now, there was evidence which came in on the threats which Mr. Mpuyo claims that he was receiving from the third accused person. Mr. Makande said, no, I never heard any threat being issued by the third accused through me to Mr. Mpuyo, that if you don't authorize payment or make payments, then something will happen. Now, when Mr. Makande came to testify, I looked at him and assessed him, and at some point he mentioned that he had been in custody with Mr. Mpuyo, and that Mr. Mpuyo had come and was just speaking to himself. When pleased, he said, no, I didn't hear what he was saying. But later on, the third accused in cross-examination, I think led him to now start saying that Mr. Mpuyo was saying that, oh, this is because of Deputy Inspector General Opani, who is trying to frame some people. So when I assessed Mr. Makande, I found him not to be quite a truthful witness who would be ready to say some things which initially he wasn't prepared to say. There was also Mr. Brown Pinganjira, who came in as a witness, and he denied that he knew of any threats coming from the third accused to Mr. Mpuyo about payments. It's striking that Mr. Pinganjira, when he was summoned by the court to come and testify, first time he came, he said, no, give me time, I can't testify, I'm getting threats, and I want to arrange my security. I'll come and testify when I'm ready. One wonders who was making threats to him. And later on, when he came in court, he said, no, I don't know about any threats. And his words were, I can even hold a Bible to say that I'm telling the truth. And looking at the witness, I was not quite impressed with his credibility and his invocation of the Bible, that he had come in and said, I'm going to come and testify, I want to organize security, I'm getting threats. And then he comes and says what he said. So I'm addressing the issue of the third accused also together with the first and second accused, particularly on the issue of conspiracy. The state has submitted that Mr. Manondo was the linkman who was taken in to hire the first accused because of his knowledge in guns, and he was an ex-soldier who shot Mr. Mpuyo. So whether there's evidence of a conspiracy at all between the three accused persons, any meeting of the minds, Also at this juncture, I have to mention Mrs. Jesse Musa, who was a maid of the third accused person, who gave evidence and said that on the morning of the day Mr. Mpio was shot, Mr. Mpio had gone to the third accused's place and shared drinks, and then he left a big bag of money which was put in the bedroom. She couldn't carry it, it was too heavy. She had access to all the rooms in the third accused's house, so she knew what was happening there, that the second accused had access. He was an errand boy of the third accused, Nyamata wa Kasambara. That was Jesse Musa's testimony. And at some point, she was shown to have told an incorrect statement about the young son of the third accused. She claimed that the young son was with her at a civil club a day after the shooting of Mr. Mpio. But Mr. George Mkondiwa, now Chief Secretary to the government, said no, the young boy was in Salima with his father. So that Jesse Musa was incorrect on what she had said. So as I said earlier on, whether somebody is incorrect on a particular point, whether you throw away all their evidence, or you look at other evidence which might corroborate what they have said. The accused persons brought to my attention the English case of Goodman versus Faber pressed still on how courts assess evidence, credibility, where the Court of Appeal said it is generally acknowledged that it is difficult even for experienced judges to decide by reference to the witness's demeanor whether his evidence is reliable. Memory often plays tricks, and even a confident witness who honestly believes in the accuracy of recollection may be mistaken. That is why, in such cases, the court looks to other evidence to see to what extent it supports or undermines what the witness said. So, this witness, Jesse Musa, said that Mr. Manondo was Mr. Kasambara's Nyamata wa Kasambara, errand boy, and we had a witness who came in, Mr. Lutepo, who said that he was introduced by Mr. Manondo to Mpio through Jivunde, and that Manondo used to drive Jivunde around to an extent that he thought that Manondo was a driver of Jivunde. And the DPP has argued that that shows the errand boy nature of the second accused. Now, I observed Madam Jesse Musa in her testimony. She was forthright and very brave. When asked by the third accused whether she liked his wife after she was fired by the family, she was frank enough to say, no, I never liked her. Some other witness may have tried to lie about this or explain it away. So this witness was true in the essential aspects of her evidence. And I am inclined to believe the material aspects of her evidence. Now, back to the communications between the three accused persons. After Mr. Mpio was going around on the 13th, he said he got a call from a minister ending with sevens, a lot of sevens, and he lied that he had gone to Kasungu. 3 minutes after receiving the response from Mr. Mpio, at 8:28 p.m., the third accused sent an SMS to the second accused. That's 8:28, on the night Mr. Mpio was shot. 8:43 p.m., the second accused called the third accused for 5:44 seconds. And the call data records show that the second accused was at cell site 82213 3G City Center 1. And the third accused was at cell site 3203 Capitol Hill G3. Around 10:43 p.m., second accused calls third accused for 500 seconds. And after that discussion, second accused is seen going towards the direction of Mr. Mpio's residence, about 10:43. Mr. Mpio is shot, and I put the time to be around 11. The second accused is captured at 11:12 p.m. by Airtel cell site 43G1, which serves Ufulu Gardens, Optimism, German Embassy, the Mpio residence. Mr. Goela said, she said earlier on, that the way the towers are tilted is that to ensure quality, you don't have spillovers. It's 90 degrees or 120, so that 43G1 ordinarily does not cover Pacific Mall, where Mr. Manondo said he was around the time in question. And it has been submitted by the DBP that Mr. Manondo testified that he went to Pacific Mall to meet his brother, Dauga. But Dauga said, no, I never met Pika Manondo. So again, to emphasize that Mr. Akuyeri, who came in to testify for the accused persons, sort of appeared to contradict the evidence of Mr. Goela, an area witness, that possibly somebody at Pacific Mall could have been caught by the Airtel cell site 43G1. But he said that that can only happen where it is peak hours, not off-peak hours. At 11 a.m., the time that Mr. Manondo was caught by 43G1 was an off-peak hour. So that he must have been in the area where 43G1 covers. The Muslim area, German Embassy area, Full Garden area, Mpio residence. If he was in a Pacific Mall, he could have been caught by the strongest signal in that area, the one in area 10. So, well, the DPP has submitted that the communication between Mr. Kasambara and Mr. Manondo from 8:28 and so on. After some communication, something to 11, Mr. Manondo is going towards the direction of Mr. Mpio's house. To the DPP's mind, that is showing that people are giving each other instructions. Go this way, execute a mission. And on the night Mr. Mpio was shot, at 00:10 2:03 a.m. in the a.m. Second accused phone is captured by Kanengo Tower, which is next to Area 43. And the DBB submits that this contradicts what Mr. Manondo had said, that he was at Shentemba. At 18 minutes past 12, after Mr. Mpuyo, in the early hours of the morning, was shot, Mr. Manondo's phone is captured by Silver Stadium Tower in Area 43, which is where he resides. 0039 a.m., Mr. Manondo calls Mr. Kasambara, 78 seconds. 2:41 a.m., after Mr. Mpuyo was shot, while still in Area 43, Mr. Manondo calls Mr. Kasambara, call lasting 362 seconds. Then you have 3 hours later, 6:28 a.m. That's when Mr. Manondo calls Mr. Kumwembe. So he slept for only 3 hours. From, I don't know, maybe he was waking up and making the calls, pressing the calls. But it's just 3 hours from the call to Mr. Kasambara, when there's a call to Mr. Kumwembe, and the two phones are seen going to Deza. Mr. Manondo's phone comes back to Lilongwe, and Mr. Kumwembe's phone goes back to Blantyre. And 9:26 a.m., Mr. Manondo calls Mr. Kasambara, 2:76 seconds, when he's coming back from Deza, around Nanjiri. Later on, Mr. Kasambara is in Salima discussing matters of state, the lake dispute. Thabo Mbeki, former president of South Africa, is there. Between 12:18 and 12:20, there were 9 SMS messages sent by Mr. Kasambara to Mr. Manondo, according to the DPP. And between 12:24 and 12:29, 5 SMSs are exchanged. So you have almost 14 SMSs in an hour, according to the submission from the state. And the DPP feels that these chats between Mr. Kasambara and Mr. Manondo could have waited while they were being done when Mr. Kasambara was busy with matters of state. Simply shows that what had happened, there was something that was bothering them very much, that they were communicating each other about. And according to the state, that's the discussions or instructions on the shooting of Mr. Mpuyo. And the state has again relied on the case I discussed earlier on to show that inferences can be made from communications by cell phone. And that's the case of Director of Public Prosecutions versus Varlac, British Virgin Islands. After analyzing all the evidence in this case, I find that the state has made out a case of conspiracy to murder against all the 3 accused persons, and I convict them accordingly. Bail for the 3 accused persons is hereby revoked, and they shall be remanded in custody.
From the High Court of Malawi, Lilongwe Registry, the judge has made his ruling, and if I'm correct, the ruling is that they've been found guilty for the count of attempted murder against MacDonald Kumwembe and Pika Manondo, and on the charge of conspiracy to commit murder for all three, including Raphael Kasambara, also found guilty. I have with me Mr. Crispin Sibande, who is also an attorney, to give us a little bit of insight what this means. And thank you so much for joining me this morning.
Thank you.
I think first, what does this mean?
Yeah, what it means is that the three accused persons who were charged with the different offenses, for the first accused, Mr. Kumwembe, and the second accused, Mr. Pika Manondo, they are answering two charges. This was after the judge had made a case to answer. You remember that at first there were 6 accused persons,
Yes.
so the judge had separated at a case to answer level and remained with 3. Now, out of those 3, 2 were charged with attempted murder and conspiracy. And then only Mr. Kasambara was answering a charge of conspiracy to both the 3. So he, at a level of case to answer, he had separated, and Mr. Kasambara was only answering the case of conspiracy, while Mr. Kumwembe, Pika Manondo were answering 2 charges, conspiracy and attempted murder. Now, what the judge did, if you look at the judgment, he spent a lot of time discussing the evidence, and he had a couple of subject matters that he had come up from the judgment, and he discussed those subject matters based on evidence. The judge made a couple of observations. He was saying that when he's sitting as a judge, it does not mean that witnesses are very consistent or truthful in everything, but he has tried to come up with a judgment looking at everything else. And again, he tried to look at each individual in terms of what was the involvement in the case. First of all, on Mr. Kumwembe, the judge looked over a couple of things. One thing that the judge was analyzing was, where was he? Because in the case, Mr. Kumwembe had raised a defense that he was not in Malawi, he was in Mozambique. Now, the judge analyzed that from different angles. One was the issue of the passport. The judge discussed that the evidence that before him was that the passport was stamped both in Malawian side and on the Mozambique side. But at the same time, there's a question about the cell phone. The judge spent time discussing the issue of the cell phone. In his analysis, he does not believe that the accused person could have surrendered that cell phone to somebody else known as Luciano Chiumbuzo. The judge believes that the phone was with him and he was communicating, and therefore the issue that he was in Mozambique was not correct. There was also a part that the judge spent a lot discussing. We call it a defense of alibi. He says this is a defense that when an accused person knows that he will rely on that defense, he was supposed to give notice in terms of that where he was, whom he met, and all that. Now, on final analysis, the judge, it was his finding that he does not believe that Mr. Kumwembe in Mozambique was in Malawi, and the phone was always with him, and he was communicating with with Pika Manondo. Then the judge also came up to the issue as to who shot Mr. Paul Mprio. The judge also spent a lot of time discussing. He was saying, according to the evidence of the guard and the evidence of Mr. Mprio, what came out was that Mr. Mprio did not clearly identify who shot him, but he was able to mention the description. So the judge looked at the evidence of the guard whom the judge observed that, according to the evidence, was inside and peeping through the window, and Mr. Mprio, who was in the car. So he says what comes out according to the judge in the judgment is the issue of a tall, young, slim man. So the judge said, according to him, Mr. Kumwembe is not a boy. He describes him as a tall, slim man. And therefore, in the description of the judge, that description fits Mr. Kumwembe. And then he talked about the issue of Mr. Pika Manondo. In evidence, the judge says Mr. Pika Manondo was saying that at one time when he was answering the phone, he was in the Pacific Mall in Area 10. And then at one point, it's being described that he was in Area 43 and then on the issues of Area 10. Now, on that issue, the judge said he was going to look at the issue of call logs. In fact, he discussed a lot about the question as, can you convict a person on the purely on the basis of call log? According to the judge, he's saying that the case is on the principles are on a case-by-case basis. A judge cannot simply say, I am not going to convict a person on call log or I'm going to convict a person on a call log. It's every judge has to look at the case before him or her. So he says for this particular case, the judge observes according to the evidence, both from experts from the Airtel and also the call log, that Pika Manondo and Mr. Kumwembe were in a discussion and they were communicating often. So that also, it was his finding that these people were communicating. The judge also discussed the issue of the money. In evidence, it was found out that Mr. Kumwembe had money more than 2 million, and that money was found in Vumbwe when he was being arrested. Now the judge was discussing where was this money would have come from, and also there was the issue about the money being deposited. So what the judge was explaining that according to him, it was important for Mr. Kumwembe to explain how that money came into his possession. So he says the explanation made by Mr. Kumwembe to him as a judge, he says it was inconsistent.
We see now Mr. Kumwembe being led away. Mr. Kumwembe is being led away. The judge, to continue on the issue, same issue of call logs, if I was hearing right, that also discussed how Mr. Kasambara and Mr. Manondo were communicating through text messages. Mr. Kasambara also being led away. The judge also discussed how Mr. Kasambara and Mr. Manondo were seemingly sending each other text messages at a time when Mr. Kasambara was on state business. Yes. Can you explain how the judge ended up using that?
So, in judgment, what we're doing is that we're analyzing what the reasons that the judge has given on coming up with the verdict. So, I was on a point where talking about the money. So, the judge says that Mr. Kumwembe, his explanation on the issue of how was found the money, he says there were two explanations which were contradictory. And therefore, the judge concluded that his explanation on the money could not be sustained in the court. Then there's an issue about the communication between Mr. Manondo and Mr. Kasambara. According to the judge, there was an issue as to whether Mr. Ompio could authorize issues of payment. And then out of that, what would be the discussion? So the judge says that in his evidence, in the evidence that was before him, he concludes that Mr. Pompeo was influential on issues of payment. As a result, he has looked at a couple of people who testified in terms of the influence Mr. Pompeo had. So first of all, he says that somebody from the Reserve Bank had come to tell the court that there are certain payments that Mr. Pompeo had made using his powers as a budget director. And also, it was very clear at the position, according to the judge, at the position of Mr. Mpio, that he was an influential person. Now, he was saying that because Mr. Mpio had testified in court that Mr. Kasambara was pressurizing him to make certain payments. Now, what the judge explained and analyzed is that there are two witnesses that came. That was Mr. Fumale Makande and Mr. Brandon Mpinganjira. Now, the judge says that both Mr. Makande and Mr. Mpinganjira, they were very unreliable in terms of the evidence that the court could have considered. But what the judge, according to the evidence, he observes that there was a communication between Mr. Mpio and Mr. Kasambara, and he says that Mr. Mpio had actually lied to Mr. Kasambara that he was coming from Kasungu that particular day. Now, in relation to Mr. Manondo, the judge says it is his finding that Pika Manondo was an errand boy for Mr. Kasambara. Now, the judge had in fact to the testimony of the house girl at Mr. Kasambara's house, and there was a little bit of a discussion, because there the judge said, acknowledged that the testimony of the house girl was not in totality correct, but the judge observed that she was a brave witness, and the judge considered part of the facts as admissible in court, and he had considered that. Why was that? There was an issue about the son of Mr. Kasambara, because the house girl was saying that she was with the son of Mr. Kasambara, but the chief secretary, Mr. Mkondi, had said that in fact Mr. Kasambara was in Salima with the son. But apart from that, what the judge concluded was that the issue that Mr. Pika Manondo was an errand boy of Mr. Kasambara, to him as a judge, he finds it as a fact. Now, since he finds is at a fact, he says then there were a discussion, and it was relation to call log. Apart from those discussions, in fact, the judge spent time analyzing phone numbers and when were people talking and at what time. And he also concluded that the submission by the DPP that there are 14 SMSs at one point between the Mr. Manondo and Mr. Kasambara, when Mr. Kasambara was supposed to be doing state business with Thabo Mbeki and other presidents on the lake dispute. He says to him they were discussing, he says it is inferred that they were discussing something in relation to the shooting of Mr. Mpio. Now the judge says because of those circumstances, especially when they call up, that's why he found the three of them guilty on a charge of conspiracy.
Absolutely, and as you can very well see that there is a lot of activity as people are running around trying to get reactions, trying to get interviews of this. Would you say that this is a landmark judgment, considering that this has been going on for at least 3 years now?
I wouldn't say that it is a landmark case, criminal case. The system in Malawi is that the case produce evidence, then it comes a where the accused persons come up with a case to answer. They come to testify, and then it's up to the judge to analyze evidence. What I've seen here is a judgment where the court has given reasons in terms of the observations, the testimony that were there, the kind of challenges there, the kind of legal principles that the judge talked about that lawyers maybe have to examine. But I would expect that the accused persons are going to appeal. But at the same time, I want to mention that we have had a number of big cases in the country. This is one of the high-profile cases in the country. First of all, you are dealing with a budget director in a country who is a very senior person in government, and him being shot. It's a big thing in the country, because you know that in Malawi we are not a violent society. It's not common to hear people being shot. So we found that this was a high-profile person. The second part is that it was also involving a former minister, a person of high profile in the society, and find that he was being prosecuted. I think it's a high-profile case. Would
you also say that the fact that several other high-profile persons were called in and involved. Even Mr. Raphael Kasambara, there were inferences at the very first time when the case was first brought to court that he was going to even call former President Joyce Banda. Of course, he ended up not calling any witnesses, but Mr. George Nkontiwa himself was called in as a witness. Mr. Brown Mpinganjira himself. All of these were some high-profile people, and of course, also the issue that this is the case that people say opened up and the whole Cashgate scandal. Would you also say that that's one of the reasons why people have been extremely interested in the case?
Yeah, if you look from the very beginning, many people have been very much interested in this case because circumstances, a budget director being shot, it's just banting on the reasons why she was being shot, and then people being arrested, then the issue about Cashgate, all that. So it has been, it has been a very big interest to many people in the country. And also to me, the fact that the case has been concluded, because you will notice that in this country, there are a couple of high-profile cases that have not been concluded. If I can compare, this might be a next case after the case of Dr. H. Kamzubanda, John Tembo, Makuria Mlunguzi. A case of involving high-profile people, whereby it has been concluded, regardless of the outcome. But in between, you have of cases that are still hanging. If you remember, of Muluzi is still hanging up to now, the corruption case. You notice, you may recall the case of Kasim Chirumba and Yusuf Matumula. Those cases have not been concluded. You remember the case of the arrest of brigadiers. You remember that. On issues of treason, the case have not been concluded. So this is one of the high-profile cases which the state has prosecuted and concluded, and also involving so many interests in the country, and many people wanted to know what was happening and what is the conclusion of this matter. And also, there were a couple of emerging issues that the judge also discussed that will also be interesting to people like students in the law faculty or those interested in the criminal law. The issue about call-logs. It's
very interesting. The fact that they were able to pull them up, and there were timelines associated with that. What does this mean in terms of how far we're going for what it means for Malawi as a country?
Yeah, it's a very interesting, and I am talking as an analyst and looking at how the case has been discussed. The judge talked about GPS versus a call log. He was saying it would have been better if we had the GPS location, that when you are talking on the phone, exact point should be known. But in the absence of that, we still have to use the call logs that exist. And the judge was looking at the experts that explained. There was a discussion about a tower in Area 43 and Area 10 and Silver Stadium. They were able to explain that if you are speaking from this tower, then your position will be on this way. And there was also the issue about off-peak and peak hours. So those are kind of principles and the issues of technology and law, and that's why the judge spent time discussing the issue about when do you on the basis of a call log. So saying that every case has to be judged based on what is there. And also, interestingly, in terms of the movements, there was a mention that Mr. Kumwembe was one time in Dedza, Mr. Pika Manondo was in Atenje. In fact, there was a discussion because Mr. Pika Manondo had said that he was actually in Gentemba, but he says that if you look at the call log, it showed that he was not in Gentemba. And in fact, the witness who had come to testify for Manondo did not confirm that indeed I was with Mr. Pika Manondo at Gentemba. So these are kind of interesting principles that are being discussed by the judge, which at the end of the day, as a country, we need to review them. And as I said, I expect that the accused persons are going to appeal to the Supreme Court, and it will be interesting how the Supreme Court will also look at these kind of technological issues, which to a certain extent centered in the discussion by the judge in terms of analyzing the evidence.
tili ku high court ku Lilongwe pamene oweruza milandu apereka chigamulo ndikuwapeza kunena kuti Pika Manondo, Macdonald Kumwembe komanso Raphael Kasambara awapeza olakwa pa mlandu ofuna kupha, komanso Raphael Kasambara ndi mulandu wopangana tinganena choncho eti. Ndipo lero pa nthawi ino pamodzi ndi Crispin Siwande amene akutifotokozera tsatanetsatane kunena kuti kodi kwenikweni zimenezi zikutanthauzanji.
Ndeno kufotokoza kwake tinene motere. Poyambirira mlandu unali ndi anthu 6 amene amayimbidwa mlandu mchaka cha 2013. Ndiyeno chaka chatha April 2015 ajaji ataunika umboni umene unaperekedwa ndi aboma adachosapo anthu 3. Anachosapo ulendo wachina Lutepo ndi Daudi Manondo ndi Robert, ndi anasala ndi anthu 3. Pa anthu 3wa Pika Manondo ndi Kumwembe amayankha mlandu wa upo wokonza kuti aphe munthu. Ndiyeno Honorable Kasambara amayankha mlandu onena kuti kupangana ndi anthu zoti apange zachiwembu. Ndiye chimene chinachitikira lero nchonena kuti ajaji anatenga nthawi kuyang'anayang'ana ndi umboni umene unali nawo unali mkhotimo, umboni umene udachokera kuboma ndi umboni umene unachokera kwa oyimbidwa mlandu. Ndiye mu judgment yawo imene apanga maminisi ochepa apitawa amaunika zinthu zosiyanasiyana. Mfundo yoyambirira imene ajaji anaunika njoti kodi amkwiyo adaombedwa nthawi yanji. Ndenkhani janakamba ajaji anaunika umboni unalipo. Iwo akuti akuona kuti kwa nthawi yeniyeni imene amkwiyo adaomberedwa gadi wawo ananena kuti woji analibe, koma iwo ajaji akhulupirira kwambiri madokotala Dr. Ntaba ndi Carlos Valera amene amanena kuti awandi akatswiri za chipatala. Umboni umene adapereka kwa iwo ajaji ukuoneka kuti wathandiza kuziwa kuti amkwiyo adaomberedwadi, komanso zikuoneka kuti nthawi inayi itadusa 11 koloko usiku. Ndi panabweranso nkhani ina yokhuzana ndi oyambirira aja Kumwembe ndi Pika Manondo. Ajaji anaunika kwambiri nkhani zingapo zimene zinatuluka. Mfundo yoyambirira ina kulo kuli timati defense. Mlandu uja ukayambidwa kunena kuti unali malo akuti umatha kuwafotokozera amene akuyimba mlandu kuti mu nkhani ine ndinena kuti nali kwakuti timati alibi. We are the defense on that you are not where you were, you are somewhere else. Ndi panali nkhani ya Kumwembe. Panali nkhani yonena kuti Kumwembe anali ku Mozambique. Nkhani inali pa passport. Komano iwo ajaji akuti mukuunika kwawo kwa umboni umene unalipo sakukhulupirira kuti Kumwembe anali ku Mozambique. Anakamapo mfundo zingapo. Panali mfundo ya foni. Iwo akuona kuti foni ya Kumwembe amayankhulana ndi anthu ambirimbiri, komanso zoti anasiyira m'bale wawo Luciano Chimbuzo sakukhulupirira. Akunena kuti munthu ukampasa foni sikuti iye angamayankhule ndi anthu ambirimbiri. Ntchito yake ya munthu uja imakhala kuyankha message kapena foni imene ayimbiridwa, koma kuti iyeyo aziyankhula ndi anthu angapo. Ndiwo kuona kwawo ajaji akuona kuti iwowo Kumwembe foni imene janali ndi iwowo. Anaunikanso ajaji mayendedwe akuti Kumwembe akuti umboni umene uli pa court pa iwowo. Kumwembe adayenda ulendo kupita kwa Vumbwe ku Blantyre kudedza mpana ku Lilongwe. Andimene amayenda mucha amagwisa ntchito foni yawo. Kwa umukuona kwa ajaji sikuti munthu amene wampasa foni munthu ungamane ukuyenda ndi foni usakugwisa kumagwisidira ntchito. Akuonesa kuti Kumwembe amagwisa ntchito foni ndipo foni inali ya iwowo. Ndiye panali nkhani ya kodi munthu amene anaombera amkwiyo anali ndani. Iwowo mwakunika kwawo akunena kuti tikaunika zoona kuti amene anamuona munthu ombera ndi ndani, kwa iwowo sanapeze munthu amene adaloza mkhoti kuti amene anaombera ndi ndani. Ajaji anasaunikapo sonena kuti mwina panali kofunikira kanthawi kena kake kuti anthu aja awayale ndipo mlandu uja pofufuza paja munthu alodze kuti anandombera ndi uyuyu. Koma iwo ajaji aunika zimene zinabwera ku court. Ndiye ku court kuja akuti chimene ajaji aona panali munthu anali wocheperapo wantali kathupi kocheperapo koma wantali ndipo munthu anali wachinyamata. Akuti iwo aunika kuti Kumwembe si mwana ndi munthu wachinyamata komanso ndi wantali wochepa thupi. Ndiye kwa iwo kuona kuti zimene anafotokoza Mkwiyo ndi zimene amanena agadi awo, ngakhale sananene kuti kufunika nkhope kuti ndi uyu kumulodza, koma amene anafotokozera kuti munthuyo anali wantali wochepa thupi, akuona kuti ndi akumwembe amene anapanga zimenezozo. Ndipo analinso kuwunikira kwa Pika Manondo. Mene ajaji ananena ndionera kuti Pika Manondo akuoneka kuti anagwira ntchito ndi akumwembe. Ndipo panali nkhani ya munthu amene anavala akuti mene amaomberedwa Mkwiyo, panali munthu amene anavala mask kapena hudu, ali pali kusiyana neti gadi mene amanenera ngati kuti munthu waona mask. Ndiyeno Mkwiyo akunena kuti munthu anaona hudu. Ndiye ajaji akuti gadi anali nkati amayang'ana pa window, saka anaona kuti munthu wavala mask. Komanso iwo akunena kuti Mkwiyo mwina ndi amene anaona. Komano iwo ajaji akunena kuti chifukwa choti Pika Manondo ndi Mkwiyo amaziwana, kwa iwo ajaji akuona kuti ndi Pika Manondo amene anavala chinthu pamene zinthuzo zimachitika. Ndiye kwa iwo akaona zokambirana kuzera mkologu pakati pa akumwembe ndi Pika Manondo. Kwa iwo ndi umboni umene aupeza pa khoti. Ajaji apeza kuti iwo anthu awiri aja, kwa iwo ndi umboni umene uli mu khoti, akuwapeza kuti ndi anthu olakwa pa mlandu wokoza upo wopha munthu, kuti amakonza kuti aphe Mkwiyo.
Komanso pa nkhani ya upo yomweyo Raphael Kasambara akupezeka kunena kuti akutchulidwa ndipo apezedwa olakwa pa nkhani yopanga upo kuti aphe munthu. Kwenikweni ajaji oweruza mulandu afotokoza motani?
Nkhani imeneyi ajaji mene afotokozera anawunika mbali zosiyanasiyana. Ndinena ananena mwamvemvemva ajaji kuti iwowo anawunika kwambiri anthu osiyanasiyana amene anapereka umboni. Kwa iwowo avomereza kuti ena sama umboni wawo umakhala ngati kuti chizungu timanena kuti inconsistent, imakhala inconsistent, kukhala ngati umboni uja pena pake umene ufotokoza odukaduka, koma iwo aja kuti awunika nkhani yawo yonse mene umboni waperekedwa. Chimene iwo ajaji akunena nchonena kuti anawunika kuyankhulana kwa pafoni pakati pa Pika Manondo, akumwembe komanso ndi Mkwiyo. Anawunika nkhani zizimotere akuti panali nkhani yonena kuti Mkwiyo amanena kuti ali pa chiopsezo. Ndiye panali nkhani yoti kodi Mkwiyo anali ndi mphamvu zopereka kuti kodi ndalama za boma angalipire kuti. Kwa iwo ajaji awunika ntchito imene Mkwiyo amagwira imene amayang'ana budget ya boma, kunena kuti ndalama zipite kwa kuti. Ndewo akuona ngati kuti iyeyo Mkwiyo tinene kuti bambo Mkwiyo anali ndithu ndi mphamvu zoti amanena kuti amata kupereka mphamvu kuti ndalama zimpereke kwakuti. Akuti panali munthu amene anachoka ku Reserve Bank kuzaperekera umboni, amene anazapereka maumboni onena kuti pali ndalama zina zimene boma linapereka zimene Mkwiyo okha ndi amene akuziwa chifukwa chani zinaperekedwa, komanso ndi anthu ena amene Mkwiyo akuziwa. Ndiye anaona kuti apapa zikuoneka kuti Mkwiyo anali ndi mphamvu ndithu yolamula kuti ndalama zipite kwakuti. Ndeno panali funso kuti kuni ubale wa Mkwiyo ndi Kasambara unali bwanji. Kwa iwo ajaji akuone umboni wawo mmene awunika akuoneka kuti panali ndithu zokambirana pakati pa Mkwiyo ndi Kasambara. Anawunika mbali yosiyanasiyana. Anawunika nkhani ya wantchito wawo Kasambara amene anazaperekera umboni kunena kuti Mkwiyo anazabwera ku nyumba kwa Kasambara. Komanso anawunikanso umboni wa Mkwiyo amene akuti amayankhulana ndi Kasambara amaopseza. Ndi siku limene zinachitika zimenezi Mkwiyo ananamiza Kasambara kuti auchoka ku kasungu. Ndiye iwo ajaji anapezanso kuti Pika Manondo akuti ndi uthamanga titero chichewa chake kandi chokonza kaya kuti uthamanga. Komano ajaji ananena kuti anali mnyamata wa Kasambara. Ndanena zimenezi kuti amatumikira kunena kuti apite kwina ndi kwina. Zimene wajaji kuti umboni umene unawo aupeza pa khoti ndona kuti Pika Manondo amatumikira kwa Kasambara. Ndiye iwo anakuti mukaona mafoni mene amayankhulana ajaji anapanga ndi ndondomeko mene akuti mene aonera kunena kuti Pika Manondo anali akuyankhulana pa foni ndi Kumwembe, komanso amayankhulana pa foni ndi Kasambara. Ajaji anazanena kuti mazulu aja panali kuyankhulana isanachitike, zitachitika ma 11 ma 12 ali kuyankhulana, ma 2 am kunali kuyankhulana, mpana ma 6 am kuyankhulana. Komanso panali siku limene iwo ajaji akuti umboni wawo kuoneka kuti Kasambara amagwira ntchito yaboma kusalima, kunali ma president ngachina Thabo Mbeki ndi chief secretary anali kusalima. Kumano panali kuoneka kuti Pika Manondo ndi Kasambara anatumizirana ma message 14 ajaji akuti munthawi yochepa. Kwa iwo ajaji akunena kuti izizi zikuonesa umboni wonena kuti anthu awawa panali kukambirana zimene zinachitika. Ndiye iwo ataunika jaji wanena kuti anthu atatuwo pa upo wokambirana kuti apange za chiwembu akuwapeza onse olakwa. Komano Pika Manondo ndi Kumwembe awapeza olakwa kuti iwowo anakonza chiwembu chopha munthu, amafuna kupha Pompwiyo.
Ndiye tifunse kunena kuti pa mulandu wofuna kupha munthu umene Macdonald Kumwembe komanso Pika Manondo awapeza agamula kunena kuti ndi olakwa, sana patseno pa Chingerezi mmati sentence kunena kuti kodi ndezita bwanji. Now milandu imeneyi akakupeza olakwa, kodi chigamulo pomalizira chimatokhala chotani?
Zona ndi mmene tamvera mu khoti muja anthu awawa apeza olakwa. Ndinene kuti mphamvu yozenga mlandu imakhala ndi bwalo. Apapa ajaji mtambo ndamene amazenga mlandu aunika umboni iwowo apeza anthu amene anali mkhoti mwawo olakwa. Ndiyeno pa mlandu wokonza kuti kupha munthu, chiwembu chofuna kupha munthu, chizungu attempted murder, malamulo athamana kuti munthu uja akhale moyo wake wonse kundende. Chimene timatanthauza ku malamulo ndichonena kuti mulandu uja akanena kuti ukhale kundende moyo wako wonse, sisithandauza kuti akakupasadi moyo wako wonse. Nzotheka khoti dikutha kutero, komano nthawi zina amaunika mfundo zosiyanasiyana. Mulandu wopanga okonza kupanga za chiwembu, conspiracy, munthu amakhala 14 years in prison. Ndiye chimene chichitike nchonena kuti pakhala tsiku limene anthu amene apezeka olakwa aitanidwa afotokoza mbali yawo zifukwa zimene akuonekera kuti akhoti awamvere chisoni kuti asapase chilango chachikulu. Pamene popo ndi khoti likazaunika zifukwa zimene zichapereka zicha azapanga chiganizo choti apase zaka zokwanira bwanji. Komano ndinene kuti ineyo imene ndikuonera amilandu aja amene apeza olakwa aliso ndi ufulu apilu zimene ajaji apeza. Chifukwa muone kuti amene dziko lathu lilireti zinthu zikusintha. Kalekale kunalibe ma cellphone, pano pakuli ma cellphone. Ajaji anayankhula ndithu nkhani za science kuti pali nkhani ya GPS ndi kologo. Amanena ajaji kuti tikanakhala kuti dziko lathu lino ndapa mwamba kwambiri, mina GPS ikanathandiza kwambiri kuziwa kuti munthu uyu yakuyankhulayo kweni ali pakuti. Komano chifukwa choti science imene ija tilibe, ajaji anaunika kwambiri nkhani ya kuyankhulana kwa anthu, komanso ndi mafoni awawa amakhala ndi tinganene kuti amaziwa kuti munthu uyu akuyankhulira kwakuti, munthu uyu akuyankhula kwakuti. Iwo ajaji anatenga nthawi yayitali kukamba nkhani imene iyi, chifukwa amafunsafunso lenera kuti kodi nzotheka kuti munthu ungamupeze mulandu mpana kumpeza wolakwa chifukwa cha nkhani ya imene akuti kologo ndiona kuti ndondomeko imene ukuyankhulana ndi anthu. Ndiye muli machine mwamba mmene mumo amene makampani ngati NM Airtel anakhazikisa, amene amaona kuti munthu amene akuyankhulira kwakuti akuyankhulanso kwakuti. Ndi ajaji anatenga nthawi kukamba nkhani imene iye mu mulandu amanena kuti iwo akuona kuti nzotheka ndithu kuti munthu utha kuyimbidwa mlandu mpana kupezedwa wolakwa chifukwa cha umboni umene ulipo wokhuzana ndi kayankhulidwe kwa foni, kupezekaso kuti foni iyi ukuyankhula kutiko. Ndiye ndikuona ngati kuti izizi ndi zinthu ngati zanyowani. Ndiye tiona kuti mwina ngati ku Supreme Court nkhani ikapitaso akambaso, koma tionanso ngati ophunzira ku Chansa College amene akuphunzira za malamulo komanso maloya amene akupanga za malamulo akhala ndi chidwi kuti aunike kwambiri judgment ya abwalo imene apanga kukhuzana ndi zinthu zokhuzana ndi science komanso ndi mayankhulidwe kuti uli kutiko munthu amene ukuyankhula.
We're speaking with Mr. Crispin here, who is explaining to us a little bit about what has happened in court. Mr. Macdonald Kumwembe, Mr. Pika Manondo have been found guilty of to murder Mr. Pompwiyo, and of course Mr. Raphael Kasambara also been found guilty, together with the two, of attempting, or rather conspiring to murder Mr. Pompeo. Now we're asking Mr. Sibande here to say, what does this mean? Kind of sentence do these charges face? What does it mean for the accused? What does it mean?
Now, for the accused person, I think one thing you saw it very clear. They were on bail. Now, today, that bail has been revoked. And you saw, you also showed viewers that now those people are back in prison and now on a charge, on a point of being convicted, that have been found guilty of an offense, and then they have gone to prison. Now, as of now, in terms of the accused persons, they'll spend time to discuss and prepare on the kind of submissions to produce to the judge, the kind of circumstances the judge should consider in sentencing, because after the stage of conviction, the next stage is that of sentencing the accused person. So we'll wait to hear the submissions from the accused person on those two charges for attempted murder, that is for Mr. Kumwembe and Mr. Manondo. Will have to adduce evidence in terms of what we call mitigating factors. These mitigating factors, you explain yourself why the court should be lenient to you, and that the court should consider giving you a lesser sentence. And then for three of them, including Mr. Kasambara, we also hear mitigating factors on why the court should be lenient to them in terms of giving them a lesser sentence. So then the court will pass a sentence on what to be the appropriate sentence, looking at the mitigating factors and the charge sheet they were answering.
Now, lastly, what kind of sentence do these charges fetch?
Now, when you look at the charge of attempted murder, the maximum sentence is life imprisonment. Now, in law, we say that the maximum sentence is reserved for the worst offender. However, we have seen judgments in this country where we have seen judges passing a maximum sentence. Now, I don't want to speculate what the judge will pass on the sentence on the attempted murder. Now, on conspiracy, we know that in our penal code, the maximum sentence is 14 years. As I've said, we expect the judge to listen to the mitigating factors and then decide what will be the appropriate sentence, looking at the circumstances of the offense committed. However, we know that this is a high court. The accused persons are also free to appeal to the Supreme Court, especially on a charge of conviction, which is the basis that they'll be sentenced. They'll be sentenced because they've been convicted. So I expect that the accused persons will appeal to the Supreme Court on the issue of conviction.
Well, my thanks go to Mr. Sibande for spending time with us and explaining to us exactly what this judgment means. Reporting for Times News, live from the High Court, Lilongwe Registry, Limbigani Kamlongera, inviting you to continue Times TV.